Fantastic. Well, good morning, everyone, and welcome to the Bingham Centre's Rule of Law podcast. I am Isabella Taylor, and I am a youth and engagement volunteer at the Bingham Centre who will be hosting today. The aim of this podcast is to essentially demystify the rule of law in the areas that genuinely affect us in our day-to-day life. And the rule of law can sometimes be seen as a very abstract academic concept, and we want to bring it back down to earth. And today we're going to be doing that with housing rights. I'm very excited to have Liz Davies KC from Garden Court and Morayo Fagborun Bennett from Gatehouse Chambers with me today. Barrister Liz Davies is a specialist in all areas of housing law, but she particularly focuses on homelessness and the allocation of social housing. Liz has been described as one of the most outstanding, highly regarded and dedicated barristers in the country. I'm just going to embarrass you a little bit, I promise. And, she's committed to really acting for people who are homeless, for tenants in need and other occupiers. And she was also ranked as a star individual in social housing by Chambers UK 2021. So she couldn't have a better person here to discuss all things housing rights. And also Morayo Fagborun Bennett, who I just learned was actually pupil supervised by Liz Davies, which is amazing. And she is a specialist landlord and tenant and real property barrister at Gatehouse Chambers. Now, Morayo has a particular interest and experience in discrimination cases. She also chairs her chamber's equality, diversity and inclusion committees and volunteers for the likes of the Free Representation Unit and Advocate, which just demonstrates the sort of pro bono work that is so integral to the housing rights sphere. Some of those access to justice issues I'm sure that we will get into in our discussion today. Morayo also sits in Yorkshire as a deputy district judge, so I'm sure she can be very helpful in talking about how we balance some of the competing interests here and kind of give us some insight in that regard. So without further ado, enough from me. Let's kick off. So with a very simple question to begin with. What do you think the rule of law means to you, and how do you think the rule of law operates in the housing rights sphere? Morayo?
Yes, I'm glad you started with such a simple question with a clear definition. So to me, the rule of law, it means, in addition to what people usually think, which is the law applying equally to all of us. So we're all equal before the law, and the law should apply equally to all. Citizens should be governed by established rules, so not arbitrary rules, and there should be judicial independence. But further to that, to me, it also means there should be protection of our civil liberties and respect for essentially fundamental rights and freedom. And this is where the housing rights issue comes in. So there's going to be a background question is, well, what exactly is required to meet the minimum standards for individuals to live? Because that's how you work out what fundamental rights and freedoms are. And then, of course, we're going to have to look at what's wrong with our current system.
Absolutely. And as you say, the rule of law really does cover all of those issues, but thank you for putting it into the context of housing rights. Liz, what are your thoughts on that?
Well, I mean, we have some important protections, which I have to say don't come principally from the common law. They come from statute, from Parliament passing legislation. So in most cases of types of occupation, whether it's people who own their own houses and have mortgages, or whether it's people who are renting either in social housing or in the private rented sector, you can't, for example, be evicted without a court order. Somebody who wants to evict you, a landlord or the mortgagor, has to go to court, get a court order, prove that they've got a right under the law to get possession of your property, get that court order, and then usually use the bailiffs to evict you. So you can't normally be arbitrarily evicted. That's extremely important. What is also important is that we do have a welfare state safety net around homelessness. It's a net with quite a lot of holes in it, because obviously there are a lot of people who are homeless and who are not helped by the council. But there is a minimum level of help available for people who either have children or are vulnerable in some way and are homeless, and they are entitled on the whole to be helped by the council in terms of being provided with emergency accommodation, usually hostels, and an offer of accommodation in the longer run. As I say, that is not perfect, because obviously we see people sleeping on our streets, which is something of an outrage in the 21st century. And there is a whole panoply of what's called hidden homelessness. So people who are not on the streets, but they're not being helped by the council, and they're not in their own home. They're often sofa surfing, staying with friends, or living with family in circumstances where they'd want to live independently and so forth, but they can't afford to do it. So we do have a welfare safety net in relation to homelessness, but it's not perfect. Far too many people drop through it. And I suppose the third point to make is that whilst we do have those protections in law are only worth something if people can actually access justice in order to be able to use those protections and rely on those protections. And as you will know, and as everybody watching this podcast will know, then litigation is extremely expensive. Unless you're very rich, and if you're very rich, you're probably not looking for homeless help from the council, because you can afford to house yourself, nor are you in a cheap private rented tenancy. So unless you're very rich, you're going to want legal aid to help you pay for representation in court, and legal aid, particularly housing legal aid, has been slashed over the last decade. To the extent that it is very hard outside of the big cities to find lawyers who specialise in housing legal aid, and even in the big cities, those lawyers are massively overwhelmed with demand and cannot help everybody who approaches them. So there is the real problem about access to justice and enforcing the rights that we have.
Absolutely, and thank you so much for that overview. It's especially really important and interesting as well to highlight things like what you said about eviction, how that can't be sort of arbitrarily done. You need a court order, but also looking at how those protections exist, but how effective can they be if people can't access representation to stand up for them in the situations when those rights are breached. And that's certainly something that I think has come across in other parts of this sort of rule of law podcast and other areas of law. It's just unfortunately the case that, as you say, legal aid funding being cut so much has such a snowball effect on lots of areas beyond they even envisaged. But in terms of social housing, in relation to kind of that specific area of housing rights, Liz, would you mind giving us a bit more insight into how that sort of inability to access justice can cause problems in social housing, and where, you know, the shortage of social housing that we're seeing in the UK right now?
It's I mean, everybody politically active around the area of housing agrees that there is a housing crisis. The government agrees that there is a housing crisis, and social housing, by which we mean council and housing association, the housing has been starved of funds for 40 years, since the early 1980s. The effect of that is that there are about 1.6 million households on council waiting lists in England, where they are waiting for the possibility of getting either a council or a housing association property. Last year, councils in England let 40,700 properties. So you will see that that demand massively outstrips supply on that, and that's a real problem. The policy of various governments, from the Conservative government of the 1980s was that private rented tenancies would meet that demand. But the problem with that is that private rents are massively unaffordable. They are unaffordable for people on benefits. There's been a recent report that shows that if you are on universal credit, then you cannot afford private rents in 98% of the country. And for those who are not on benefits, private rents are at the moment spiraling out of control. There's a report in the newspaper today's the 21st of October, that says that private rents in London have increased by 16%. So that's well over inflation levels in the last year. So we have a really serious housing crisis on our hands. The government has some policies. They have a plan to end rough sleeping, and their plan is to end rough sleeping in 2 years' time, in 2024. And they published details of that plan about a month ago in September, and put some money behind that for local authorities. And I'm not a finance expert. I think councils broadly welcome that, and that's a good start, because we should not have rough sleepers sleeping on our streets. There are also plans to build 300,000 new properties, but the number of those that might be council homes and actually genuinely affordable for people is not known at all. Most housing campaigners reckon that any government would need to be committed to building 90,000 council homes a year in order to start to solve the crisis, and we don't have anything like that from this government, or indeed from any political party at the moment.
Yeah, of course. No, thank you for that. And as you say, the efforts to solve rough sleeping, as you mentioned earlier, are only part of the problem. And with hidden homelessness, it's more than just people on our streets. As you say, it's abhorrent, and that, as you said, we absolutely shouldn't have people on our streets, but people who are impacted by homelessness, or not just people who you see walking past on the streets. It's also those hidden homelessness, and they really can't get forgotten in these conversations, as you've highlighted. Morayo, what are your thoughts on the sort of how all these issues apply within the private rented sector?
Well, I mean, in relation to the private rented sector, you've got, rights that currently exist to offer some protection to tenants. So changes have been brought in relation to the maximum deposit that a landlord can now require. That's now 5 weeks. In terms of housing condition, there's good domestic law in place. Section 11 of the Landlord and Tenant Act 1985, which has been in place for people will be very familiar with. So it implies terms into tenancy agreements that afford a right to basic repairs to the structure, installation, and various other matters. And more recently, there's the Homes Fitness for Human Habitation Act 2018, which came into force on the 20th of March 2019, and now applies to all tenancies. And you've got the Housing Act 2004, which sets out housing and health standards for local authorities to enforce. So that's all great in relation to the existence of those domestic laws. And in terms of protection of eviction, if it's a discretionary ground for possession, there's going to be the court's going to consider what's called the test of reasonableness. So even if the ground for possession is made out, so you've got rent arrears, you've behaved in an antisocial manner, if it's a discretionary ground, but it doesn't stop there. The court will consider whether it's reasonable to make a possession order, and then whether it should be suspended or postponed. So they're going to consider a number of factors, including the reason for the breach, the seriousness of the breach. Effectively, they're considering whether eviction is a proportionate response to the breach. Obviously, if it's a mandatory ground for possession, there's more difficulties, which we'll will go on to talking about it, especially in the private rented sector. So, but it's, having said all of that, in terms of the housing condition, as Liz has said, it's great having the domestic law, but who is going to enforce it? We've got local authorities that are overwhelmed, actually, with a number of tasks that they have to perform, the lack of funding for them to undertake those. And and on top of that, they do, they've got duties to enforce some of the housing condition matters. And to be frank, a lot of that wasn't taking place. So you ended up with lots of people going for CFAs or to the magistrates court to try to enforce their rights when their properties were overridden by mold and mice infestation and various other matters with mixed results, sometimes settling their cases for effectively insufficient money, and then the lawyers getting their money out of it, but things not actually being being properly resolved. And you've got issues with lack of legal aid for tenants in any event. You mentioned earlier, Liz, about the duty solicitor scheme, and I have to say, I mean, it's when I'm sitting as a judge, it's they make a real difference, and I wish more people turned up to their first possession proceedings, because they've got quality advice being provided by solicitors who and I will rearrange my list to make sure you have a proper time to talk to a duty solicitor. So I always say turn up, because there is help at that first, whilst it's still there, there is help at that first hearing that might make a difference between being given another chance, being able to come to some agreement or arrangement, and losing your home and only fighting it at the warrant stage when there's not going to be legal aid, or there's not going to be a duty solicitor involved.
Yeah, no, thank you. That's really, really insightful, and especially against the backdrop of what Liz was saying about kind of the realities of some of these housing conditions. Hearing just how much domestic law there is there in theory to protect against this sort of thing, it's really interesting to hear kind of the difference between like the law and the practice in that sense, and what happens in reality. And some of your insight there as well from sitting as a judge is really important, and I hope anyone listening takes that advice. Turn up to your first hearing, use the help that's available. It sounds like it makes a world of difference. So Liz, do you have anything to add on that point about how maybe the rule of law isn't protecting people in that sense because the domestic law isn't being applied?
Yeah, so two things. The first is that the duty solicitor scheme for possession hearings is hugely important, and after a great deal of lobbying, the government has actually put some more money into that. And it does mean that if you're faced with a possession claim, so that the landlord or the mortgagee wants to evict you, and you have a court date to turn up, do turn up, and you should, in most courts, find that there is a solicitor available at the court who will take your details and put whatever points need to be made. And if you've got a full defence, then the case can get adjourned and you can find legal representation. That's absolutely great. It's a bulwark. But there is the point about housing rights and the rule of law is not just that there are good domestic laws but insufficiently enforced. There is also a glaring legal problem, which again everybody agrees is a legal problem, and that is Section 21 no-fault evictions in the private rented sector, whereby the landlord is entitled to evict their tenant they have to get a court order, but they will be entitled to the court order, providing that they've got the paperwork right, provided that the tenancy deposit is protected and basic requirements of landlords to provide gas safety certificates and energy performance certificates and so forth are being complied with. But providing all that is the case, then if the landlord gives the tenant 2 months notice and then goes to court, they will get a court order actually on the papers without a court hearing, because they will have ticked all the relevant boxes. And the huge problem with no fault eviction, one, obviously it means literally that tenants can lose their homes through no fault of their own for no reason whatsoever, except that the landlord wants the property back, and the landlord might want the property back because they want to rent it to somebody at a higher rent that the existing tenant can't afford, or for whatever reason that they've fallen out with the tenant. So they might want the property back for either good reason or bad reason, but it creates huge uncertainty for tenants. And private rented tenants talk about having to move year on year, not having the security of a place that they know that they can call their home in the long run. It also means, of course, that if tenants try and enforce the rights that Morayo was just talking about, then landlords are likely to greet that with a Section 21 2-month notice eviction. And whilst there are restrictions on the extent that they can do that, those restrictions are not tough enough, and so it actually prevents tenants from enforcing their housing rights. Widespread agreement that Section 21 needs to be abolished. It was in the Conservative Party manifesto for December 2019, the general election, and in June the government published a white paper with plans to abolish Section 21. We haven't yet seen draft legislation, and we're recording this podcast the day after Prime Minister Liz Truss has resigned. Nobody knew whether Prime Minister Liz Truss would go through with the commitment to abolish Section 21. Indeed, about 2 weeks ago, when she was still Prime Minister, there was the rumour that she was going to renege on that promise and keep Section 21, and then she U-turned and said that she would be abolishing Section 21, but we haven't had any draft legislation, and politically at the moment everything is very, very chaotic, so we don't know. But everybody agrees, all political parties, all housing campaigners, and indeed the National Residential Landlords Association agree that Section 21 needs to be abolished. It's caused huge heartache and uncertainty for tenants, and it is a legal mechanism that stands in the way of people enforcing their housing rights.
Yeah, that's really interesting, because I think sometimes we think about the rule of law as like, it's always going to bring good things, and the law is always there to protect people, but you just highlighted a legal sort of these no fault evictions is a legal measure that can hurt people and cause all this uncertainty, which, as you say, is slightly mirrored in the fact that we don't know who our PM will be next week. We don't know who may or may not be abolishing Section 21, so that remains to be seen, but fingers crossed, because as you say, it's the amount of uncertainty that it causes and how much it conflicts with sort of some of the principles underlying the other housing law provisions identified by Morayo. It just seems in total conflict. So following on from that, I thought it might be interesting to discuss what you think about housing as a human right, and how perhaps if we saw housing less as a privilege or as something that you should be grateful to have, and more as something that we are entitled to in the 21st century, and how reframing our understanding of housing might actually offer more protection and prevent things like Section 21 from even being able to come in as legislation. Morayo, would you like to give some thoughts on what your thoughts are on housing as a human right?
Yes, just before we move on to that, one thing that's probably important to mention is in relation to the affordability of the private rented sector. So because this creates a real difficulty, which can be particularly acute for those who are on benefits. So the ONS statistics in November 21 said that the private rented prices paid by tenants in the UK increased by 1.7% in the 12 months to November 2021. And that's the highest annual growth rate in private rented prices since July 2017. So that it creates real difficulties when the private rented sector is eye-wateringly expensive and unaffordable for individuals. So it's one of the matters that we're going to we need to keep in mind. But moving on to housing as a human right. So Article 8, we've got, of course, the right to respect for home, private life and family. But it's important to note that it's not a right to a home. In Iraq and UK, the court said, well, Article 8 doesn't amount to a duty on the state to provide a home. And so that gets 14 months on the street doesn't demonstrate a minimum level of suffering sufficient to breach Article 3, apparently. And that obviously creates a real difficulty for individuals.
Yeah, that is just shocking. I can't, it just doesn't compute. But I mean, as you say, I suppose that's where maybe we need to introduce kind of more protections in that sense. I mean, any thoughts on Article 8, Liz?
Article 8 is not sufficient for the reasons that Morayo said. It is a right to respect for your home, which means, to be honest, at the most limited basis, it has meant that when social landlords, council and housing associations are bringing possession claims against their tenants on what's called mandatory grounds for possession, in other words, under the domestic law, then there's no right to consider whether or not the ground that they are arguing is reasonable, whether it's reasonable for the tenant to be evicted. In those circumstances, exceptionally, then the court could consider the tenant's circumstances. Exceptionally, nobody really knows what exceptionally means. That principle of law of Article 8 was the result of a ping-pong battle between what was then the House of Lords and the Strasbourg European Court of Human Rights. It went back and forth, this proposition, with the House of Lords resolutely saying it didn't even apply in those circumstances, until eventually the Supreme Court, in I think its first or second decision, once to become the Supreme Court, said, okay, Strasbourg is right, and there is that very limited requirement that courts could consider Article 8 in exceptional circumstances in cases brought by social landlords. Doesn't apply to cases brought by private landlords. The Strasbourg case has confirmed that. And as Morayo said so eloquently, it absolutely does not mean a right to a home. There is a lot of discussion at the moment around whether there should be a human right to a home, a human right to housing, a human right to adequate housing. And that is quite exciting. But one has to then step back and think, what does it mean? Partly it means resources, because there's not a lot of point in enacting something in law that says that there is a human right to housing if there aren't the resources to back it up. And we've just been talking about the appalling housing crisis. That's solved principally not by law. And we see that most dramatically in South Africa, because the South African Constitution, enacted in 1994 as a result of the end of apartheid and the bringing in of democracy, included the right to housing as a constitutional right. And the Constitutional Court in South Africa said quite quickly that that meant that if people were being evicted, the state had an obligation to make sure that there were alternative methods of housing. So that's the legal right. But anyone who knows anything about South Africa knows that thousands, indeed millions of people are both either homeless or in very inadequate housing whatsoever, because it's a very poor country and it has huge inequalities of wealth. And so enacting something that says housing is a human right, we have a right to adequate housing, whilst I have some thoughts on what you would do with the legal framework, which we can come on to, then the basic problem is making sure that that's backed up with resources.
Absolutely. And I think as you say, and it's a big part of what the Bingham Centre does, like the human rights are kind of without substance if they can't be applied and invoked properly, right? It's not good enough to just say, oh, we all have a right to this, and you know, equality is really important. We actually have to, it has to be real and it has to be tangible. And I think that was a really interesting comparison with South Africa. I didn't actually realise that they had it kind of entrenched in the way that it was, and how without resources it's not as effective as you might hope it would be. Now, when it comes to housing rights, homelessness, evictions, we obviously know that there's an intersectionality issue. LGBT people, for example, make up a huge proportion of young homeless people. I know Sean Fay in her book has a whole chapter dedicated to transgender people and how homelessness impacts them. And then additionally, obviously, prisoners coming out of prison homeless. I myself spent a year volunteering at St Mungo's, working in temporary accommodation, and some of the kind of experiences and adversity that prisoners face in this country is really not spoken about enough. And then additionally, obviously, on top of that, there's also domestic abuse and how that disproportionately affects women, and the way that race intersects with all three of those issues. So I was wondering, while we're looking at sort of a potential way forward and housing as a human right, if we could also think about how we might address some of those intersectional issues as well that come into the housing rights space. Morayo, do you have any thoughts on that?
It's I like getting the easy questions.
Sorry.
Yes, well, I mean, in relation to the particular groups, as we mentioned earlier, some groups are provided with priority need in relation to homelessness. So with prisoners, as you've mentioned, some will have priority needs, but only if they're vulnerable. Otherwise, they're discharged at the prison gates to homelessness. There's a duty to refer, but that given everything we've said about the overworked and under-resourced local authority, and the difficulties on the ground in terms of getting people's needs assessed and dealt with appropriately, it's easy to see how prisoners can fall between the gaps. In terms of domestic abuse, again, there's a priority need, but it's there have been some difficulties in the past with in terms of allocation, if there's a residency criteria, and how, if you decide to flee from one borough to the other, how is that dealt with? Yes, you're not resident, but I mean, the reason that you're not resident is because you were a victim of domestic violence, so you've gone as far as you can in order to try and keep yourself and sometimes your children safe. And if you meet that obstacle, while something that seems, perfectly legitimate at first sight, that, oh yes, you have to have resided somewhere for 2 years or before you can apply for scarce social housing, might make sense. With certain groups, you can see that it can create real difficulties, and the breakdown of relationships is currently the highest reason why people apply as homeless, contrast to being threatened with homelessness, where the highest reason is Section 21 notice. So it creates real difficulties, and of course there's also then concerns about the suitability of any offers that are made in relation to the accommodation. You get people who are often very, very desperate, and all these groups I know are desperate. They're thinking in particular of domestic abuse and those fleeing with children. Trying to get children back into school and being offered accommodation that are substandard and having to make those very painful decisions about whether in fact you move into this inadequate housing or you stay in a situation in which you are subjected to domestic abuse, which includes, as we all know now, controlling and coercive behaviour, and all the risks and harm that brings with it. Liz, I don't know if you want to add any more.
Domestic abuse is exactly the case study that shows the big gap between law and practice, because again, that, as Morayo said, that the law is good. If you are if you have accommodation, but it's likely that continuing to live in it means that you will be subject to domestic abuse, then you are homeless and entitled to some help from the council. And if you've left the accommodation because of domestic abuse, then you will have a priority need and be entitled to emergency accommodation from the council and to one offer. But that's not a panacea, because even though you have those opportunities to be helped by the council under homelessness, you come into what is the very fragmented service that is the homelessness service. And so, as Morayo said, you end up in hostels, you end up being given one offer of accommodation that could be literally hundreds of miles, because London local authorities make offers of accommodation in the Midlands and the North because they can't find affordable accommodation in London, literally hundreds of miles from your support network, your children's schools, medical facilities, so all of those things that are important to anybody, but particularly to women fleeing domestic abuse. And partly because of the pressure on resources, then councils are still taking a very binary and sledgehammerish position to women who come to them saying that they've had domestic abuse. They are not listening to women properly. There's a very important report just been published a month or so ago by an organisation called the Public Interest Law Centre, which talks about women who have approached different women, 32 different stories, 32 London local authorities. All of those women approached those local authorities and were either turned away and told to come back with some sort of proof of domestic abuse. And as we all know, that is, one, unlawful, because the law says that you should accommodate people and then make inquiries, not the other way around. And secondly, as we all know, in the domestic abuse world, then there isn't necessarily proof, and so people have to listen to the women. I'm saying women, obviously. Most people
Yes.
fleeing domestic abuse are women, some are men. So they are being turned away. They're also finding that they are being judged in that if they turn down offers of accommodation that are a long way away from where they had been living, where the domestic abuse had taken place, then a council's knee-jerk response is, well, maybe you weren't really suffering domestic abuse, because you're saying that, well, surely somebody who's suffering domestic abuse wants to get as far away as possible. That is an incredibly ignorant assessment of how domestic abuse works. And certainly, I mean, a couple of years ago, I had a case that was routine, in that it was typical, but it so happened that this woman was able to get good legal advice, and we were able to go to court, and we ended up in front of a very good judge. And that is exactly what had happened. She had been offered accommodation in the Midlands by a London local authority, again, because it's very hard to find affordable accommodation in London. We understand that. When she had turned it down because she needed to be near her friends and her sisters, because she had left domestic abuse, the council's response was, well, we're not really sure you suffered domestic abuse at all. And the judge said very insightfully, it's for her to know where she's safe. She could be safe in a similar area to where she was subject to domestic abuse, and still be able to be in touch with her support network and so forth. And what councils don't do in relation to domestic abuse is listen to women. Now, that's not confined to domestic abuse. They don't really listen to anybody who are approaching them and asking them for homelessness assistance, because they are overwhelmed, and because it's, as the Amnesty report says, it's in a sense, homelessness help is treated as a benefit or a reward, something someone should be grateful for rather than a right. But it's particularly stark when it comes to women who are leaving domestic abuse. So we need to have a good look at this, as policymakers need to have a good look at this, not just in terms of the law, but in terms of how it actually acts in practice.
Absolutely. And as you say, it's such a good case study to kind of demonstrate how, what I think is clear from what you've just said, that the right to housing goes so much more beyond housing. And I used to work at Rights of Women, and it's so much more than just a roof over your head. It can mean the right to education for your kids. It can mean the right to work because you feel safe and you feel able to leave your house, or because you feel that you can have childcare and you can therefore access employment. You know, it says to view this as a very binary way, and for a local authority to try and tell someone, you know, where they should feel safe and where they should feel comfortable is kind of defeats the point. I mean, the local authority is meant to be there to support them with what they need, and obviously limited resources, completely appreciate that. But yeah, as you say, I think from what you've just said and what both of you have just so insightfully said is really demonstrates that the right to housing goes far beyond just housing alone. So I think to finish off, I would love to talk a bit about that Amnesty report that you just mentioned. And you know, the Amnesty report is all about how it is an obstacle course, and homelessness and the right to housing in the UK and trying to get assistance is an obstacle course. And there's kind of a lot of sometimes what feel like arbitrary hurdles that you have to run through. But at the end of that report, there is thankfully sort of some suggestions for how we might get ourselves out of this housing crisis in the UK. And I think to finish off the podcast, I would love to hear maybe some positive things from this suggestions, you know, that maybe there's some hope, maybe there's a light at the end of the tunnel. Yeah, just, you know, is what can be done, and what do you think will actually tangibly make an impact beyond just saying it's a human right? Morayo, would you like to kick off with another very easy question for you?
Well, yes, no, again, I'm very thankful for that. You mentioned intersectionality earlier, and 24% of young homeless people are LGBTQIA+, and that is, you know, especially concerning. And whilst, you know, 16 to 17-year-olds and care leavers have priority need, the fact that you've got, nevertheless, a huge chunk of homeless people who are have that protected characteristics and are still ending up in dire need is very concerning, and that is something that any solution is going to have to seriously look at. And the other matter that I wanted to mention, which relates to race and sex and gender, is immigration status. It can render people not eligible for homelessness assistance. So that can put you in a position in which you are a victim of domestic violence, and you then have to make the decision about whether to stay in that situation, or if you try to escape, if you try to move out, you know that actually, if you've got no recourse to public funding, or you've overstayed, or something, you can end up in you can end up effectively being forced to stay in unsafe situation. There is a gap in the law, and a gap that needs to be plugged so that, you know, people are not being forced to stay. Now, I've also used the term women, and of course, you know, it's you know, the I mean, I sit as a family judge. The majority of the victims of domestic violence I see are women, but of course I do also see victims of domestic violence that are men, and so, you know, nothing is intended by that. But obviously there is you know, one of those areas that needs to be looked at. So having possibly avoided answering the original question that that you asked in relation to positivity, what does housing as a human rights looked like? Well, one thing would be decent housing conditions in all rented properties, so that there is the will, the money to enforce what domestic legislation provides for. And that's probably also going to have to involve the provision of legal aid or the means to adequately enforce those rights, because it's no good if actually you're trying, it's a badly pleaded case that misses the point, because you don't know what you're doing, or the issue isn't raised. So that's one of the matters that I think housing as a human rights is going to look at.
No, thank you. Don't worry, you didn't avoid my question. I mean, that was, it was in a vision of a future where we don't have those problems. So no, thank you for that. It was really insightful. And Liz, anything to add?
One negative and two positives. So the negative is I completely agree with Morayo about the appalling position that the no recourse to public funds condition puts on all sorts of people who are subject to the hostile environment, but in particularly those who are experiencing domestic abuse. And there were attempts when the Domestic Abuse Bill, as it was now, Domestic Abuse Act 2021, was going through Parliament in 2021. There were attempts to bring protection for victims, survivors, principally women and girls who were subject to domestic abuse, and those were voted down. And that is a real shame. Real shame is understating it, because of course, if you have no ability to flee and get state help, then the abuse only continues, but it's magnified because the fact that you can't escape is held over you. And whilst there are some refuge places available for women who can't access benefits, have no recourse to public funds, they're very limited indeed, because refugees are strapped for cash, so they have to mainly charge rent through housing benefit. So I mean, that is just appalling, and that is an important negative thing that at the moment there is not political will to resolve. The two positive things is, I do think for the first time in decades there is a political consensus that there is a housing crisis, that housing crisis is not just resolved by increasing the supply of private rented properties, which, as I say, was government policy for decades, that the private rented sector would step in and meet the demand. And therefore there's the consensus, we hope, around the abolition of Section 21. There are growing calls for the ability to control rents in the private rented sector. Sadiq Khan, the Mayor of London, has called for him to be given some powers through primary legislation in order to look at controlling rents, capping rent increases in London. So the idea that private rents are spiraling out of control is now accepted, and there is some discussion about what to do about that. That's a huge step forward from the last 30 years. My second positive is, I think that there are a lot of positive conversations happening around homelessness, and my take on what housing as a human right would involve includes that everyone who is homeless would be entitled to emergency accommodation, so a roof over their head, and help to find longer term accommodation, whether that's social housing or private rented housing that's suitable for them. And to a certain extent, Scotland and Wales are showing the way. Scotland abolished the priority need test in 2012. So if you are homeless, unless you've made yourself intentionally homeless, then you are entitled to that emergency accommodation. and help finding accommodation. The Welsh government has massively restricted the becoming homeless intentionally test. So that no longer hangs over people who apply as homeless, and they are looking at calls to abolish priority need. The English government so far has not shown any interest in looking at that, but there is a lot of pressure on them to do so. And as I say, Scotland and Wales are showing the way. The other thing that showed the way was an amazing piece of action that the government did when the pandemic hit and when we all went into lockdown 2.5 years ago, because they sent a instruction. It wasn't an act of parliament or anything in a sort of legal sense, but it was an instruction to all local authorities to provide accommodation to everyone who was sleeping rough, regardless of immigration status, regardless of priority need, just bring them all in. And it was called everyone in. And it's had some long-term effects. The effect of that is that people who were accommodated on an emergency basis, who would not normally have been entitled to accommodation from the council, not only got their emergency accommodation, but were then helped into longer term accommodation. Something like 37,000 people in England were helped into longer term accommodation. There were obviously very good public health reasons for that, both the health of the rough sleepers themselves and the fact that rough sleepers on the streets are more likely to be conduits of infection and so forth. So there was a real public health case for it. And the Lancet estimated that that policy initiative 6 months later had saved over 260 deaths. So that's a real benefit. And it shows, and the homelessness crisis, charity crisis tweeted this at the time, it shows that with political will and resources in an extraordinary situation of the pandemic and lockdown, then we can actually achieve the objective of not having people sleeping on our streets. And what I take from that is that we don't have to have the unprecedented circumstances of a pandemic and lockdown in order to bring everybody in and actually bring an end to immediate and visible and the most appalling manifestation of homelessness. We could implement everyone in on a permanent basis, and that gives me some hope.
Absolutely, that gives me some hope as well. I mean, that was really great to hear, and as you say, it happened, and hopefully that means it can happen again. I think what really stuck with me from what you've just said is that the public consensus is changing, and it seems like thanks to the work of people who've been campaigning for decades for housing rights, and thanks to people like yourselves who've been kind of in the courts protecting these rights for individual people, I think people are finally recognizing that we do have a housing crisis, and people are more willing to listen, I think, as well. And I think one of the parts of the Amnesty report and what Amnesty's coverage of this did was it really gave voices to the people who are experiencing it. It wasn't just, it was kind of a with, not for attitude. And I think that's going to be integral to anything that we do for housing in the UK, because it can be really patronizing and sort of pitiful or whatever in some ways to the way that we have these conversations. And I think if we have them with the people who are affected by it, and if we ask people what they're experiencing, then maybe, just maybe, we can actually address the issues properly and help people get off the streets, get permanent accommodation, and help people feel secure and have some stability, which just currently isn't there in the UK right now. But on that note, thank you so much to you both for participating today in this Bingham Centre podcast. It was really insightful, and we're really grateful for you giving up your time, especially with all the important other work that you both do. So thank you so much.